The cases, sir.
I'm sorry, Mr. Rudeness. Don't speak to this court like that. You ask for a jury trial, you're going to get a jury trial. In other words, using your common sense to fill in the gaps. That is allowed. You do this every day when you interact and make decisions. When you make decisions, you don't know everything about it.
I asked Mr. Laird what the offer was. He said 6 years.
The original offer was 4. I raised it up 2 years because he wanted to play now instead of before.
And now my client said, well, I need to talk to the judge, and I don't know.
No, he doesn't need, he doesn't talk to me. You have a lawyer. You go through your lawyer, not to
And I have
me.
notified you of on lawyer on numerous occasions, sir.
I'm sorry, Mr. Rudeness. Don't speak to this court like that. You ask for a jury trial, you're going to get a jury trial. Oh, bring the jury in.
I think we have to move. Do you want to hide that one? Oh,
Move this camera. So let me switch it to where I can see what I'm looking at. We got it on?
Yeah, we got to turn that.
I've got
You
it.
got, this camera needs to be turned. The jury's going to come in. The jury needs to be turned.
Yes, sir.
No.
I'm gonna shut this one off. I'm getting it. Trying to get where I can see.
Thank you. That looks good. And
I'm gonna have to redo it, Judge.
yeah, that's
I
that.
think they did something.
Wait till the jury comes in, just move it a little too far forward. Too back.
Stand by, ladies and gentlemen. Thank you. All right, we call number 22-40440. The state of Texas versus Xavier Judge Senegal.
Fix it. Right. I'll fix it.
Mr. Senegal is indicted with the 3rd-degree felony of stalking, of family violence. The jury is seated in the courtroom. All parties are present. Good morning to all of you, ladies and gentlemen. First thing we're going to do is swear all of you in as jurors in this case. Please raise your right hands. Do you and each of you solemnly swear or affirm that in the case of the state of Texas versus Xavier Judge Senegal, you will a true verdict render according to the law and the evidence, so help you God? Lower your hands. Ladies and gentlemen, the jury, by the oath that you have just taken as jurors, you have now become officials of this court and active participants in the public administration of justice, which is a great honor in a self-governing democratic republic that we live in. If at any time you cannot clearly hear the proceedings, please raise your hand. Let me know. I want to make sure that you can clearly hear what's going on during the trial here in the courtroom and also see the evidence and the witnesses clearly as you are listening to the evidence as it is being presented. No one may discuss this case with you during your service as jurors until you go back together to deliberate amongst yourselves on a verdict. And likewise, don't feel offended if you happen to, if the lawyers in this case, when you run into them in the hallway or in the elevators, that they do little more than nod to you. To maintain the integrity of the jury system, the law prohibits them from speaking with you until you are released from duty in this case. If someone does contact you or tries to contact you about this case while jurors, please report that at once to our bailiff. And also, do not discuss the evidence in this case with your fellow jurors until the end of the case when you go back together and deliberate. And also, when people find out you are jurors, they want to ask you, well, what can you tell me? And again, don't speak about this to your spouse, significant others, friends, or anyone else until you are discharged at the end of the trial. Then you can talk about your experiences and deliberations with anyone as you wish. Be careful about watching news reports, reading newspaper articles, or listening to any radio reports. If while you are a juror, there is a story about this case, please turn the page, mute the sound, turn the channel. Again, we don't want you to get any outside information about this case other than what's presented here in this courtroom. Now, some jurors like to take notes, and if you want to do that, that's fine. If you choose to do so, those notes are for your purposes only. You are not allowed to share them with other jurors. And one way that I see jurors do it is that they're writing notes and they can refer to them during their deliberations, but you can't say, look what my notes state. I wrote this during trial day number 2. They can't do it. You can't do it that way with other jurors, because then that would be interjecting matters which have not been formally admitted into evidence. But again, what you write in notes, you can refer to on your own if you wish. Don't go to any of the locations referred to by the witnesses in this case. And likewise, don't go out and do any field investigation of the facts of this case. You will receive all the evidence here in the courtroom. And likewise, don't look in books, encyclopedias, or dictionaries, or go to the library or review courthouse records in order to obtain information over and above what is presented to you during this trial. Please listen carefully, as I know you will, to the testimony. No testimony will be read back to you during your deliberations unless you disagree about a specific statement or statements made during the trial. Now, in just a moment, the lawyers have an opportunity to make opening statements, which are brief overviews of their theory of the case and what they intend to present. The statements that they make, all statements of attorneys, do not constitute evidence unless they are called as a witness in a case. They have very important duties in sending to you the message and advocating for their position. But again, the statements and questions of the lawyers to witnesses do not constitute any evidence. What is evidence is the sworn answers by the witnesses. That's the evidence that you will consider. Of course, the questions set up your understanding of the answers, and that's why we have a question and answer method. It's been long a practice, as early courts realized, when you place a witness on a stand and just tell them, ask them to tell jurors what they know about the event. A lot of times people aren't good speakers. They freeze, they're intimidated. They don't do a good job in giving a speech when they're not used to it. That's why we have a question and answer method that has been used for about 1,000 years now. Now, in just a moment, we're going to be going into the evidence, and your oath that you have just taken states that you will render a verdict only on the evidence submitted to you under the court's legal rulings. The evidence you may consider will consist of the testimony of the witnesses from that witness chair, and also evidence may be presented in the form of physical objects or documents, which we call exhibits. During the trial, attorneys make objections, and when an objection is made, it is necessary for the court to rule on those objections. Court judges are referred to as the gatekeepers of the admissibility of evidence. People have asked me, what have you done that helps you do your job as a trial judge? And again, I've presided over more than 600 felony jury trials. So we've done a lot. In every jury trial, something different occurs. But I tell people when they ask that question, 10 years as a basketball official, and there's so much alike between what I do and being a basketball official, except there's not 1,000 people shouting at you every time you blow the whistle. You have to know the rules, and you have to apply them fairly. And this is a compilation of several of the different rules in the first part of this Criminal Laws of Texas publication. You have right here the penal code, the Texas Penal Code, which essentially is the great number of laws that are devised to show what crimes are committed, what it takes to commit a crime, what the elements of those crimes are. And most of the criminal law is found in the penal code. A lot of other criminal cases are found in the drug enforcement laws, and a third of our caseload are drug cases. In fact, another third are crimes committed because of drug abuse. So drugs are a big part of it. So it has its own section. Then you have the Code of Criminal Procedure, this big thick section, and this dictates the rules of how a case works its way through the system from the very beginning to the end. This one is the rules of evidence, and this is what the legislature set forth are the methods that evidence is presented properly in a courtroom. You just don't say, here's a bottle, we admit it into evidence. No. You have to have a foundation for its admissibility. That has to be relevant and reliable. And if an objection is made, then the court has to rule on the objection before it is admitted. I was on the Rules of Evidence Committee that wrote this, so I'm very sensitive about the rules of evidence being done correctly. It's a compilation of laws, and that's what this whole scenario is about. It is a formulation in a form, in a procedure that is built around laws, but most importantly, the overriding concept is fairness and justice. So each of you gets to see the facts as you see them. That is your job. You evaluate the credibility of the witnesses. You get to decide how much weight and value the witness's testimony and other evidence should be given. In considering the value of the testimony of the witnesses, you can consider what you do every day when you interact with people. Their appearance, their attitude, their behavior, their interest in the outcome of the case, their relationship to the parties, the inclination of the witnesses to tell the truth, the probability or improbability of witnesses' statements. And most importantly, because in no case do the jurors get all the information possible in a matter. The law then states you can fill in those gaps missing by using reasonable inferences from the statements and from the evidence. In other words, using your common sense to fill in the gaps. That is allowed. You do this every day when you interact and make decisions. When you make decisions, you don't know everything about it. There are gaps that you use in your common sense, in your education, in your experiences in life. That is something you can bring into your decision making during your deliberations as jurors, and all other factors you feel may help you in giving the testimony of the witnesses and the degree of credibility of the evidence that you feel it deserves. The trial is going to proceed in the following way. In just a moment, I'm going to ask the state of Texas to present the indictment. The defendant shall plead to the indictment. Then the parties get to make opening statements, which are brief overviews of a roadmap of what they feel their evidence is going to present so that you can understand their theory of the case. Because of the presumption of innocence that we talked about during voir dire, the state of Texas goes first. They have the duty, the obligation, the burden to prove the case that's alleged, and they must meet that burden by a test of beyond a reasonable doubt. They will call witnesses, and witnesses will be questioned from that witness chair. After the state questions witnesses, the defense gets to cross-examine those witnesses. At some point in time, you will hear the state say, "We rest." Then the defense may or may not present witnesses. Sometimes they don't call any witnesses. They just rest right behind the state. That doesn't mean that the sky is falling. They're throwing in the towel. They're admitting guilt. What that means is I know what the final argument is going to be. The defense will state, we didn't put it on any evidence because the state of Texas has the burden to prove we can present evidence, but we believe the state did not meet their burden proving beyond a reasonable doubt. That's what they will do. I don't even have to know. I've just done it for 40 years. And that's what the argument would be, which sometimes that happens. But if the defense does place witnesses, they can do that. They can call witnesses. And after a witness is questioned by the defense attorney, the state gets to cross-examine. At some point in time, both parties will say, we rest. And when that happens, I will read to you the jury charge, which contains all the law applicable for your deliberations. The lawyers will make their final arguments, and then you will go back together to deliberate on a verdict, right through that door into the deliberation room. At all times, it is your foremost required duty under the law to see that justice is done in accordance with the law the court provides to you and the evidence presented. At this time, I'm going to ask the state of Texas to present the indictment. The defendant shall rise.
In the name and by the authority of the state of Texas, the grand jurors for the county of Jefferson, state aforesaid, duly organized as such at the July term, AD 2022, of the 252nd District Court of Jefferson County, in said county and state, upon oath in said court, present that Xavier Judd Senegal, aka Judd Senegal, aka Xavier Judd Wayne Senegal, aka Xavier Senegal, hereafter styled the defendant, committed an offense hereafter styled the primary offense on or about the 4th day of July, 2022, and anterior to the presentment of this indictment, in the county of Jefferson and state of Texas, did then and there, and pursuant to the same scheme and course of conduct directed specifically at Janice Stoker, knowingly engage in conduct that constituted an offense under section 42.07 of the Texas Penal Code, namely repeated electronic communication, and the defendant's conduct would cause a reasonable person to, and did cause Janice Stoker, a person with whom the defendant has or has had a dating relationship, to feel harassed, annoyed, alarmed, abused, tormented, embarrassed, or offended. And did then and there on or about the 4th day of July, 2022, and pursuant to the same scheme and course of conduct directed specifically at Janice Stoker, knowingly engage in conduct that constituted an offense under section 42.07 of the Texas Penal Code, namely threatening to commit violence against associates of Janice Stoker, and the defendant's conduct would cause a reasonable person to, and did cause Janice Stoker, a person with whom the defendant has or has had a dating relationship, to feel harassed, annoyed, alarmed, abused, tormented, embarrassed, or offended. And did then and there on or about the 4th day of July, 2022, and pursuant to the same scheme and course of conduct that was directed specifically at Janice Stoker, hereafter styled the complainant, knowingly engage in conduct directed specifically toward the complainant that the defendant knew or reasonably should have known that the complainant would regard as threatening that an offense would be committed against Janice Stoker, a person with whom the defendant has or has had a dating relationship, namely breaking into the habitation of Janice Stoker, and the defendant's conduct would cause a reasonable person to fear, and did cause Janice Stoker to be in fear that an offense would be committed against her, against the peace and dignity of the state, signed by the form of the grand jury.
Xavier Judge Senegal, as defendant in this case, how do you plead to the indictment as just read by the state of Texas?
Guilty.
Guilty or not guilty? Go ahead.
Not guilty.
Not guilty is entered into the record on your behalf. You may be seated. Thank you. All right, at this time, the court will allow opening statements, beginning with the state of Texas.
Please, court counsel.
Yes.
Good morning. As the judge told you, I'm not going to make an argument. This is not time for that. That comes later after all the evidence is presented. Right now, it's just kind of a roadmap to let you know what to look for, what I'm going to present to you, and what I think the evidence is going to show you. Okay? So let's start off with, in a perfect world, I would have every witness in a chronological order. But I have a police officer who's trying to get out of town today, and so I'm going to put him on first so he can get out of town, and then I'll call the rest of the witnesses. It's going to be a short case, you're going to find, because everything happened, and I'll tell you how this story goes. It happened really quick.
Janice Stoker and the defendant Xavier Senegal have known each other for many, many years. I think Janice knew him back when they were high school, around that age or younger age, and everything was fine as far as knowing each other. They weren't in a dating relationship. They just knew each other. And you'll hear Janice say that back then he was an okay guy. Then somewhere in about 2021 into 21, sometime into 22, you're going to hear that for about 9 months, they were in a dating relationship. And Janice is going to tell you that she was in love, that otherwise she wouldn't have stayed in the relationship as long as she did. You're going to hear her say that when it started, everything was fine, but she believes because of possible drug usage by the defendant that his personality changed and he became violent. And there were several violent altercations, and she will tell you that both of them were fighting physically because of the fact of the way he was trying to abuse her. She was defending herself. They fought back and forth. And this went back and forth, and she was in love. She didn't want him to leave. She didn't want anything to go wrong, but they just kept going back and forth. She's called the police on him. And I think about April of 2022. You'll hear that she'll tell you about that, what the situation was, and she left, and they still got back together. And then about June 13th, she said she's going to tell you that Janice Stoker's going to tell you that the relationship became to where he started becoming more and more aggressive sexually. That if she didn't want to have sex, he would physically hold her down. She would try to clamp her legs together, and he would force himself on her. And so at June 13th, she just had enough, and she broke up with the defendant and gave him back all his stuff and let him go his way. That's when all this began as far as the stalking. You're going to hear her say that he began texting her, coming by her house, driving by the road. He would make comments on text messages that let her know that he had been standing by her window, thought he had heard her having sex with somebody. You're going to see some security videos from Janice Stoker's house at 23, I believe 20, let me make sure I get this address correct. 2326 Pope Street, I was right. Where she had moved after he had been over that house a couple of times, I think before in May, and slept over there, but after they broke up, he was not supposed to come back over anymore. That was her house, it was in her name, and she was living alone. The relationship was over with. She'd had, right after they broke up on June 13th, she'd had a loss of her aunt, so the family was dealing with that loss. And now she's got the defendant starting to come over and make comments, starting to text her constantly. She's trying not to engage with him, and yet he's still constantly, you're going to see a lot of text messages. I promise you, I'm going to be very efficient in this trial. I'm not going to bore you with all the text messages, but I am going to show you a number of them to where you get the idea, and I'll tender in the rest of them. If you want to look at them, you're welcome to look at all the text messages. So then he starts coming to the house. You're going to see a couple of home security videos where he's standing outside the house. He's knocking on the door. He's trying to get in. He's yelling at her. He's trying to get her to come to the door to talk to him, yelling and screaming. And then you're going to see one incident where he actually goes in the house. There's a video inside the living room, and she has some friends over because she's scared. She has a cousin and her friend and her daughter over staying with her at this house. And you're going to see how the defendant just comes in the front door and they're talking, and he's yelling at Janice, trying to ask her if she's got somebody in there with her in the bedroom, and he's yelling and yelling for about 5 minutes. And when they start to call the police, he leaves. You're going to hear that on June 20th, she and her cousin, who's about 9 years old, were going to her house, and the defendant was standing out on the front porch. And as they try to go in the front, he starts trying to take her phone from her, if she has another man. He's just obsessed with this, and he keeps trying to take her phone. And you're going to hear a 911 call from her as he's got the phone. You can hear her yelling, "Xavier, that's my phone," and yelling and screaming. You're going to hear her say that She called the police because he assaulted her at the door, assaulted her 9-year-old cousin because her cousin was right there, got caught up in the fray and got hit. So her and her cousin run down the street. Janice and her cousin run down the street. Xavier looks like he's fixing to leave, so she comes back to get back in, and Xavier comes back, and you're going to see that he took a tire iron and he smashed all the windows in her car. You're going to see the pictures of the windows busted out in her car. You're going to see the swelling. You'll hear the officer say he saw some swelling on the 9-year-old girl's nose, the swelling and the scrapes on the victim, Janice Stoker's knees. That was June 20th. July 3rd, you're going to see some videos of the defendant coming and being at the house and trying to knock on the door, get to talk to her. Then you're going to see a police officer who is Michael Davis. Elisha Jones. He's the one who's going to testify first. On July the 4th, the defendant comes over there and there's a bunch of family members and he's trying to beat her. And when the police get there, there's a whole big old melee of all these people fighting and everything. And that's when I think the defendant is actually charged with stalking. It's over and done. That stops the process of this incident. So you're going to see that the reason this is a very fast trial is because it went from June 13th until July the 4th, and the pattern of behavior that was there placed her in fear, and you're going to see why. And I think once you listen to all the evidence and you see the physical exhibits, that you'll understand why Janice Stoker was afraid that there was going to be an offense committed against her or some type of violence committed against her or her family. I look forward to presenting the case to you.
Mr. Vasquez, do you want to make an opening statement at this time?
Briefly, Your Honor.
Go ahead.
Counsel, Mr. Senegal. Good morning. Welcome back. Mr. Laird has given you the roadmap of everything he thinks he can prove to you beyond a reasonable doubt. Please remember that the defense, and the judge just reminded you, and you hear it all the time on television, the defense is under no obligation to prove anything. Their job is to hold the state to its burden of proving the element, each allegation, each element in the indictment beyond a reasonable doubt to you. As bad as all that sounds, each element has to be proven to you beyond a reasonable doubt. You're going to hear me object to a lot of things, not because I'm trying to hide them from you, because I think they're prejudicial and I don't think they're relevant to the charges against Mr. Senegal. So please keep an open mind until all of the evidence is in. Everyone's been heard from. You're the finders of fact, the 12 of you. Judge will give you the law at the end of all this. Please keep an open mind until the trial's over. Thank you.
First witness statement.
Elisha Jones.
Please come forward. Raise your right hand. Do you solemnly swear or affirm that the testimony that you shall be the truth, the whole truth, and nothing but the truth? So help you God. Yes, sir. Please have a seat, please. Thank you.
You state your name for the record, please.
Officer Elisha Jones,
And how are you employed?
the city of Beaumont,
How long have you worked for them?
for approximately 5 years.
And you in patrol, I guess?
Yes, sir.
Back in July 4th of 2022, were you an officer with the Beaumont Police Department? And were you on patrol?
Yes, sir.
And did you get a call to go to an address at 2326 Pope Street?
Yes.
And is that here in Beaumont?
Yes, sir.
And is that in Jefferson County, Texas?
Yes, sir.
Okay. What was the purpose of the call that you got?
Have perfect news.
Yes, sir. It's only been a couple of years,
Yeah.
hasn't it?
Believe it, the disturbance.
Okay. When you got there, was there disturbance kind of going on?
There was absolutely.
What's going on when you got there?
So I remember there being a lot of family members, at that residence. They believed they were fighting between, the owner of the house and somebody who came trying to, get inside that residence.
Okay. Was that person there that tried to get inside the residence?
They were near violent scenes.
Okay. Were they nearby or did somebody else stop them?
I believe somebody else detained.
Okay. So, but they weren't there whenever you.
I don't believe so.
So when you came up to the house, so there was a bunch of family members. Was there a person by the name of Janice Stoker there?
Yes.
And was she the main person, the person on the house, or was renting the house?
Yes.
What kind of condition was everybody in? Were they all excited?
They were all frantic, yes, sir.
Had it just happened?
Correct.
And whenever I say it just happened, you arrived within minutes of getting the call, didn't you?
Correct.
And it appeared that everybody was still just trying to. Let's do this. Whenever police officers arrive and they get there shortly after something happens, is everybody trying to tell you something at once?
Absolutely. It's very chaotic.
Okay. And did you get to talk to Janice Stoker?
Yes.
And was she still under an excited state?
I believe so.
Okay. I mean, it was right after it happened, wasn't it?
Yes, sir.
And was she trying to tell you what was going on with the situation?
Yes, sir.
And what did she tell you that was going on?
One of her.
Judge, check the hearsay.
It's an exception, Judge. The present sense impression, officer got there right after the call had recently happened, and he said she was still under an excited state. So I believe it fits the exception to the hearsay rule.
All right, overruled. Ladies and gentlemen, when we wrote the rules of evidence, generally speaking, hearsay, that is statements made by someone else, not the person testifying, are generally inadmissible because you want it from the speaker who made the speech. That's the best form of the presentation of evidence. However, that was the general rule. We also put in several exceptions to that rule that would be admissible. Among other things, we decided that something called present sense impression, that is a statement describing or explaining an event or condition made while or immediately after the declarant perceived it, would be admissible because it was determined that has believability to it. And it's, again, a jury decides how much weight and credibility to be giving it, but that would be admissible if the jury believes it, because that in those situations, people don't have the time to make stuff up generally. Also, an excited utterance is also an exception to the rule. That's a statement relating to a startling event or condition made while the declarant, the person stating, was under the stress of the excitement at the time it was stated. And again, the Rules of Evidence Committee deemed that has believability because they didn't have time to formulate a story, and that it's just common sense that people in those states are going to just be uttering what they tend to utter, what they perceive, not having a chance to make up a wild story. Again, that is admissible. The objection is overruled. The jury gets to decide, though, how much weight and credibility you wish to give. Go ahead.
Did Ms. Stoker say how the altercation began at the scene?
Basically, she told me that her ex-boyfriend came to the residence, tried to break in. was causing problems, and previously, there were several other incidents that she encountered with him. There were other issues as well.
Okay, did she in fact show you some things on her phone?
She did, yes.
What did she show you on her
I
phone?
believe it was just a ton of messages harassing her.
Okay. Did you take photographs of those messages?
Yes, sir.
Okay, and you turned them in with the case, is that right?
Yeah, it was.
And I showed those to you earlier, didn't I?
Yes, sir.
But in order to make sure that these are correct, I'll have her introduce them. I'll tell you these state's exhibits 2A through 2H and see if those look like those messages that you took photographs of.
Yes, sir.
Those are the messages she showed you on her phone.
Correct.
And after looking at that, did y'all determine that an offense was being committed?
Correct, yes, sir.
And were you the lead officer to make the report and determine all that?
Yes, sir.
What offense did you determine was being committed?
Stalking.
So, was he there?
He was around the area. I don't
Okay.
remember exactly where.
Did you actually get to have contact with him that night?
I do not.
Okay, did you issue him anything?
I did, criminal trespass warning was issued, yes, sir.
Okay, so you don't recall whether you saw him or not?
I don't recall, but I believe,
Okay, you believe you did?
yes, sir.
Do you see him in the courtroom today?
Yes.
And can you point to him and describe an article of clothing he's wearing? What's he wearing?
I believe,
Record reflect he's identified the defendant. It's with or without a tire jacket.
without a tire jacket.
Okay, there you go.
On the man on the left, here's your record shall so indicate the witness has identified the defendant. Go ahead.
So you issued him a trespass warning. What is a trespass warning?
Stating that he's not allowed to go back to that residence.
Okay. Now, had Ms. Stoker told you he'd already been warned not to come back before?
She gave me several other, few other cases that were involved, and I don't recall. They
What?
I doubt they're the same.
Okay. But that night after that happened, did you arrest the defendant for stalking?
No.
Why not?
Just it was one of July 4th, and their city was going crazy, and also we did a report to let the detectives take care of it.
Okay. And was Ms. Stoker gonna go be with family or had family over there to protect?
Correct.
Okay. I'll pass it. Yeah.
Any cross?
Yes,
Go ahead. Yes, sir.
good morning. Officer, are you sure you issued a trespass warning that night? Or did you say you think you did?
Trespass warning was issued. I just don't remember if I gave it to him directly or not, if another officer handed it to him, but I completed a trespass warning.
Are you sure you got it?
I would believe so.
Did you see him get it?
I do not recall, but I believe he got it.
You believe you did, but you can't swear under oath that he was issued a trespass warning that night.
My reports reflect that he did, so I mean, I believe so.
Okay, I won't keep pressing you on that. But you didn't hand it to him.
I don't recall. There's a very high possibility that I did, but I just know what my report reflects, that trespass warning was completed and it states that he received it.
If there's not one, and there's not one in the file, and there's not one in the discovery I received from the state, what does that mean?
Well, trespass warning can also be verbal as well. However, I believe he received a written one, and I don't know why. The other.
It could have been verbal.
No, I mean, that's a possibility for a trespass warning, so you can also be trespassed verbally. However, we normally do a written one, which my report reflects that.
But do you recall you verbally?
I don't recall, no. I don't, it was,
Let me finish my question. You don't recall verbally giving him a trespass warning.
I do not recall.
Did you recall seeing him?
Again, I reported, my report states that he received a trespass warning and he was given it too.
Why did you decide that night that he should be charged with stalking?
Due to the continuous contacts, unwanted harassing and violent contacts made. So a report was made, however, an arrest was not made.
So this was all from what Ms. Stoker told you.
Correct.
You never actually saw him.
I didn't say that. Again, I said I did not recall.
You don't recall whether you saw him, and you decided he should be charged with stalking because of what Ms. Stoker told you.
Again, yes, a report was made, or an arrest was not, and it was up to detectives at that point to continue.
Let me rephrase one more time and I'll leave you alone. All this was based on Ms. Stoker's testimony.
I believe so.
Pass what?
I have nothing further, Judge.
Is this man excused?
Please, Judge.
You are excused, sir. Next, please.
Call Michael Davis.
Thank you.
Be careful, Chris.
Yes, I'll. Come forward, sir. Raise your right hand. Do you solemnly swear or affirm that the testimony that you are about to give shall be the truth, and nothing but the truth, so help you God?
I do.
Please have a seat. Thank you.
Have to move around with that back belt on, isn't it?
Yes, sir.
Can you state your name for the record, please?
Officer Michael Davis,
And how are you employed?
I'm employed by the city of Omaha as a police officer.
How long have you worked for them?
Next month will be 17 years.
You ever worked anywhere else as a police officer?
No.
Okay. So what have you done in your career? Walmart Police Department has always been on patrol?
Majority of the time I haven't been patrol. I've been in specialized units as well, like street crimes and SAU, things like that.
Okay. Currently you're on patrol.
Yes, sir.
Back on June 20th of 2022, were you on patrol?
Yes, sir.
And about would be early morning hours, did you get a call to go to a place on 5520 Concord?
Yes, sir.
What was the purpose of going to Concord Street?
It was, the original call was in reference to an assault that occurred at different locations.
Okay. So where you were going was not where the assault occurred?
Right.
Is Concord in Beaumont, Texas?
Yes, sir.
Is it in Jefferson County, Texas?
Yes.
So when you arrived, who was the complaining witness when you got there that you found?
May I refer to my?
Sure.
The original victim was Janice Stover.
So when you got the call, was it just minutes before you arrived?
Yes,
And when you got there, did she appear to be upset?
yes.
Did you get the gist of what had occurred?
I did speak with the victim, Ms. Stoker, and she ran down what had occurred.
Judge, I'm gonna object as hearsay.
I can cut to you.
I'm sorry. Let him complete his answer. Did you complete your answer?
No, sir. Ms. Stoker had ran down why was the reason why she called the police, sir.
Okay.
Overruled, there wasn't a substance of what was said. That doesn't constitute hearsay. Go ahead.
When you got there, did she appear to be still upset from the incident that happened?
Yes, sir.
And was she visibly upset?
Yes, sir.
And you could tell by the way she was talking, was she kind of still under the influence of what all had happened?
She was visibly upset. We see that her eyes were teary and she was elevated, I guess you could say.
You've been around people whenever you show up to a scene, you can tell when they're calm and everything's good, right?
Yes, sir.
And they've had a while to think about it. In this instance, was that so with Miss Stoker?
No, sir.
Was she talking really fast? Almost fast as I talk sometimes?
Yes, sir.
Okay. Did you also see some physical signs on her
Yes,
that kind of backed up what she was saying?
I observed her left eye to be swollen. And there were scratches on her forearms, both forearms and her legs.
Okay. Was there anybody with her?
Her young niece,
Okay. The young lady that was with her, did you see anything on her that appeared to be some type of injuries?
her nose was swollen.
Okay. So what did Miss Stoker tell you while she was upset?
Judge, I object to seriously.
Good judge, it's present sense impression. I don't know about
Court
side
has-
of
The court has reviewed with the jury what a present sense impression is, which is an exception to the hearsay rule. A statement describing or explaining an event or condition made while or immediately after the defendant, the declarant perceived it. And how long did you say this was that you got to the scene after you had been called? Minutes, hours?
Minutes.
And an excited utterance is also an exception to the general rule against the admission of hearsay. A statement relating to a startling event or condition made while the declarant was under the stress of the excitement that it had caused. Was that occurring?
Yes.
That is in that atmosphere, and the witness was in an excited or upset
Yes.
state. All right, your objection's overruled and the state may continue.
Judge, may I have a running objection through?
No, you need to make an objection each time there's a different matter that you want to object to. But the running objection is, you need to keep making an objection for each set of circumstances. But for his statements he's about to make based upon what the question was, you don't need to continue to object to that. I've overruled that. But if another question is asked, and you feel like you need to object, you're invited to do so, and then the court will rule. Okay, thank you. Go ahead.
So did she tell you that this had happened just a few minutes before?
Yes.
And was it at a different location?
Yes, sir.
And did she tell you why she had to run to Concord Street?
The victim described to me that she had tried to arrive at her residence and she was met by the defendant.
Okay.
No,
You never saw him that night, did you?
sir.
Okay, so did she say who the name was of the person that she?
Yes, sir. She identified the actor as her former boyfriend of 9 months, Xavier Simmons.
Okay,
Another name, I object to hearsay objection.
For that statement.
Yes.
same thing, Judge. It's still all under the excited utterance. All this, I would know, present sense impression. This is all one continuous story.
Is that true, sir? This is still under that,
Yes,
that point in time where you were just coming to
Yes, sir.
investigate and she appeared to be excited and upset and in a state of
yes,
emotional distress.
yes.
Overall.
So the whole time you're getting this little short story out of her, what happened? She's still under that influence of that previous incident, right?
Yes,
And this was all within just a couple of minutes while she's telling you what happened, right?
yes.
Okay. So did she say this happened? You said this happened at her residence. Where was her residence?
2326 Polk Street, Beaumont, Texas, Jefferson County.
Okay. So did she say how it began?
She said the juvenile that was with her arrived at the residence. They were met by Mr. Senegal. Verbal disturbance started because they recently broken up and he was accusing her of seeing someone else.
Okay. And did she say that verbal altercation became physical?
It escalated to physical violence, yes.
Now, did she talk about her cell phones that she had?
Yes,
Did she have a cell phone with her at the time the altercation began?
yes.
And did she say what happened to that cell phone?
She advised Mr. Senegal had smashed both of her cell phone chip too.
Okay. Would that kind of explain why she left from one location to go to another location to try to call the police? So when she,
Hold on, there was not a verbal.
oh,
answer.
is that yes or no?
Just a
All
nod.
right, no, sorry. Um, did she advise you that she tried to get away from the suspect?
Yes,
And what happened when she tried to get away from him?
her and the juvenile retreated back to her vehicle. Mr. Senegal retreated back to his vehicle, collected a black and colored tool, then approached the victim again.
And what did he do with the black and colored tool?
He smashed the windows out of her vehicle.
Did you see her vehicle that night?
Yes, sir.
And what did the windows look like?
They were shattered.
Okay. Did it match up with the story she was giving you?
Yes, sir.
So when you saw this, did you also, is that when you looked for physical injuries to see what was wrong with them? Or did you see that before?
You can see that the face was swollen, the swelling to the left.
35, is that a closer view of the center console?
Yes, sir.
Now, if the glass is consistently scattered all throughout the front of that seat, what does that tell you? Does it tell you that the impact was small or pretty good impact?
Pretty good impact, sir.
36,
Passenger seat front.
and it's got glass in it too, doesn't it?
Yes, sir.
37,
Rear floorboard, rear seat and floorboard.
that's got some glass in it, doesn't it? Looking at 38, you can tell how much.
Yes, sir.
Is that a lot of glass?
Well, it's a whole entire window.
The whole entire window's missing, isn't it? So that's a whole entire window sitting in the back passenger seat. What do you call that? What when somebody beats your car and does damage to your car against your will, what is that called? What do you charge them with? Is that an offense under the Texas Penal Code, state of Texas?
Yes, sir.
And is it something that is punishable by jail time, depending on how much damage they get?
It's based on the value ladder, but the higher the value, the more jail time it convicted. Yes, sir.
So if somebody has that happen to them, and there's been an ongoing battle between her and the person who did that, they could probably be scared that more could happen to them, wouldn't they?
Yes, sir.
And did she seem afraid that more was going to happen that night?
What-
calls for speculating.
Do you know the answer to that? In your training and experience?
For my training experience, yes, sir, yes. She appeared to be scared of him that night, yes, sir.
I'll pass the witness, Jeff. Go ahead.
Thank you. Officer Davis, how are you?
Well, sir, how are you?
Good, thank you. All the information you received that night was from Miss Stoker, correct?
And I also spoke to the juvenile, yes, sir.
So you spoke to Miss Stoker and you spoke to the juvenile.
Yes.
Did you see anything? Did you ever see Mr. Senegal?
No, sir.
Have you ever seen him in your life? Let me withdraw that question. You see him today?
Yes, sir.
Okay. And as far as the pictures, the injuries speak for themselves, correct? And the jury can assess the physical damage to the car, and
A courtroom hearing suddenly turned explosive when the defense attorney began arguing about probable cause standards and how the prosecution failed to meet its burden. Before the attorney could continue, the judge sharply interrupted and made it clear he would not tolerate being lectured on courtroom procedure. Frustrated, the judge reminded everyone he had spent 26 years on the bench and didn't need anyone explaining how probable cause hearings work. The tension instantly filled the courtroom as the attorney tried to continue speaking, only to be cut off again with repeated demands to move on. The heated confrontation quickly became one of the most aggressive moments of the entire hearing.
injuries to the people.
Yes.
Pass witness.
I have no further questions.
Is this man excused?
Please, Judge.
You are excused, sir. Thank you. Next, please.
Call Janice Stoker.
Kendall, come on up.